This program is brought to you by Rogers Xfinity, connecting you to more of what you love. Visit Rogers.com for more details.
Welcome to another edition of Living Well, Giving Well on Rogers Television, Grey County. This is episode number 23. Our host charity today is the YMCA of Owen Sound, Grey Bruce, and we'll be talking a little bit about the YMCA, and in a future program, we'll have members of the YMCA from Owen Sound, Grey Bruce join us on the program. Our charity video today, or our featured video today, will be Bruce Peninsula Hospital Foundations, which pertain to the hospitals that are located at Lions Head and at Wyerton, and we'll be talking extensively about them. Our guest today is Alex Wade, and Alex, we're talking all about wills with you once again. First of all, how are things?
Great, no complaints whatsoever. Wills are steadily flowing in at all times, so it's great. I just had 2 instruction appointments this morning, so no complaints at all, and yeah, everything's great.
As we do this program, and again, we sit in the city of Owen Sound, and I understand that this program is also seen in Bruce County as far over as Kincardine and Simcoe County. I take it they're watching in Midland and Penetanguishene, but in our region where we sit, the demographic, I would suggest, is getting older. Is that a reason that maybe we're seeing more and more wills come in?
I would suspect so. That plus the thought that a lot more people are having those open dialogues. It's more of a dinner party conversation now. I find that a lot of my clients will give us referrals in that respect. They'll say, "Oh, we sat down with the neighbors for dinner, and so the topic of wills arose, and they would realize that they hadn't revisited the actual wills in 20 years or something like that." So that, I think, is part of it. Yeah, and the aged population that we service here in our region definitely keeps mortality at the forefront of their minds. So.
Yeah, this is Living Well, Giving Well on Rogers Television. I'm Fred Wallace. Denise Reed generally is my co-host. Denise is enjoying living well in Curacao, if I'm not mistaken. She's on a big vacation, and normally Denise takes this opportunity to tell you about the concept of living well, giving well, and that is to leave a gift or a percentage of your estate to a charity. Maybe it's a charity like the YMCA, Owen Sound, Grey Bruce, or maybe like our featured video, if you happen to be serviced on the Bruce Peninsula by the Hospital Foundation. So again, we would like you to check willpower.ca for all the information and all the very easy steps to support a charity. Alex, let's talk about the first step in making a will. When do you start to make it? And I know we've already talked about this at one point in time, that somebody waited until they were in their 60s to do it.
Well, primarily, you should start thinking about it, and ideally, from our perspective, as soon as you get to the age of majority. But it should be whenever you first kind of acquire that asset. So whether or not that's the home, whether or not it's a sizable inheritance, whether or not it's just even a bank account, you should be putting in place some testamentary document in order to be able to direct what happens with that asset upon your passing, and who you would want to manage that part of your estate upon your passing. Other big ticket items would be, you have children, there's been a divorce or a marriage that you've gone through, that people have passed on. So whether or not they would be children, beneficiaries, or a spouse, these are all times where revisiting your will is required. And we really would like to see that you're avoiding any application of what's known as the intestacy laws. What would happen if you did die intestate? There is a mechanism in place, so don't worry about it. It doesn't all just go to escheat to the crown or anything like that, but it's best to have that forethought and planning in place, because then it's the people that you trust that are taking over that role for you going forward.
Mm-hmm. So wills and reviewing your wills. So there's multiple steps along the way, or steps that need to be done over the course of time.
Exactly, yeah. You should always have your initial estate plan done. You should consult with other professionals, not only legal professionals in that respect. You should always rely on accounting professionals, financial planners. You may have some complex family scenarios. So you may want to involve those that are family professionals and that sort of thing as well, if there's going to be any issues with respect to guardianship of children or disabilities. So yeah, there's always additional complexities that come out of the woodwork. We always love those clients that sit down with me and say, hey, this is going to be simple, and it turns into a 2-hour interview because we start unpacking potential tax consequences or other things like that. So it's always best to engage a professional, at least seek their consult when you're drafting these sorts of documents. And obviously, ideally, it would be best if we prepared them for you, but that I understand is not always the case. And so at least having the advice there to rely on when you're drafting these.
Alex, somewhere in time I read the 5 key things to building a financial fortune, and I think it was set a goal, use other people's money, but also use other people's expertise. And that's what you're talking about with the lawyers, accountants, and financial planners.
Yeah, we look at it more holistically whenever we're drafting wills. I'm always engaging with accountants to see whether or not the estate plan is going to be effective from a tax planning perspective now and into the future. If there's any added complications such as privately held corporations or family trusts, these sorts of things. So it's always best to have that expertise at your beck and call when you're doing it.
Do we have to talk to 2 different age brackets, or maybe multiple age brackets, when we talk about wills? You mentioned the age of majority, which I assume is 19 now, or vote when you're
18.
18, yeah, so somewhere in there. This is how old I am, obviously. So do you have to say, is there a different message to them than perhaps somebody in their mid-30s who's in the prime of their working years, to somebody who's doing in semi-retirement, who's 65 years old almost?
Certainly. Like, the context is going to be adapted to whatever the circumstances are. So somebody who's 18, just getting out of school, perhaps just has a giant student debt load or other small assets at that point in time, they can put forward a pretty simple will. Usually going to appoint siblings or parents to assist and then going to them. But as life progresses, so once that individual perhaps partners with somebody, has children, things become a little bit more complex, and yes, you're going to have to revisit it as well. So yes, it's a different conversation every time you have it. The other thing too is that it's with today's current family law context or family law atmosphere, I guess, the family dynamics are constantly changing, so they're becoming more evolved, more blended, mixed families, these sorts of things. We're seeing not necessarily a decline in the traditional married family unit, but if you're a common law spouse, it's critical that you have a will put in place if you want to benefit the other common law spouse. Intestacy laws only benefit those that are married. So again, context is definitely going to change whether or not we're talking to married spouses or common law spouses.
We joked about this in one of our previous episodes, maybe last week or 2 weeks ago, that the joke is that me and my partner will get married on my deathbed, and that way we'll be married. But it's kind of a joke that we're talking about, but it's something that we should consider much more strongly based on the way your eyebrows are going up.
Well, and the funny thing is that the law is constantly evolving. So a marriage no longer invalidates a former will. That law has progressed. So even if you did get married on your deathbed, doesn't necessarily change your estate plan. You would still need to revisit it as well. It does provide some additional entitlements under the Family Law Act, but again, that's kind of where it becomes blended, and you would want to engage, if you don't have that expertise available to you, you may even want to engage a family law lawyer to look over your estate plan as well.
Alex Wade from Middlebro and Stevens is our guest today on Living Well, Giving Well. Again, we're encouraging you to go to willpower.ca to find out the steps to support a charity. We're talking all about wills today. Our host charity today is the YMCA of Owen Sound Grey Bruce, and we'll be talking about them in detail, both on our program today and in the weeks ahead. Alex, in a case like mine, I can't remember how long I was in your office setting up the will or how long it took, which I guess is a good thing because now it's behind me. Is it a complex, I can't remember, was it a complex scenario?
So my policy, whenever anybody's scheduling an interview with me to set up a new estate plan, I always schedule it for 2 hours. I want the time to be able to sit down with the client, not only to get to know them, but to know their financial circumstances. And there's sort of an internal process that I go through whenever I'm taking those instructions. Bunch of reasons for it. Basically, we do kind of a test for capacity to make sure that you understand the instructions you're giving to us, what a will is, what a power of attorney does, knowing the nature and extent of your property, approximate valuations. Secondly, you usually appoint other people as your estate trustees who are not necessarily going to be your spouse, or it could be another trusted family member or friend. They're probably not going to be as intimately aware of your financial circumstances as you are, so I always like to have a complete laundry list of assets so I can at least assist with initiating the information gathering stages after you've passed. Obviously, you're not here to consult at that point in time. And then the third reason is that if anybody does challenge your will, that's where I come into play from a litigious standpoint. I am the witness that's put into the hot seat and cross-examined by a colleague to propound your intentions under your will. So yeah, it's a little bit of a longer process. I want to make sure that I have comprehensive notes so that I can rely on them at a later point in time. I'm never going to remember the conversation. In fact, I don't quite recall everything.
I don't remember the dates, but I know we've done it.
Yeah, exactly. But and then we get into the actual instruction appointment. So I usually bifurcate the meeting into 2 halves, and the first half is exactly that, and then the second half is actually going through and taking the instructions and then making sure that we are assessing any sort of taxation pitfalls or anything else that may arise.
Peace of mind. What does having a will do for somebody's peace of mind if they haven't already done so?
I think it's imperative to have that in place and to have the expert knowledge that it's going to satisfy your intentions on your passing. That's what estate litigation is primarily. It focuses on like interpretations of the will. So we want to make sure that it reads clearly, it's plain language, everyone understands what that will is. And then so long as you can pull it out and understand what your own will says, that gives you a great peace of mind going forward.
We're going to talk more about wills coming up with our guest today. This is Living Well, Giving Well, and Alex Wade is our guest from Middlebro and Stevens, a partner with that law firm. Our host charity today, as mentioned, is the YMCA of Owen Sound, Grey Bruce. It's a marvelous facility. I can tell you that firsthand. I don't know about all of their services, and we'll find out that at a later date. Coming up, we've got a featured video, and today we'll be looking at the Bruce Peninsula Hospital Foundations. That deals with the hospitals that are located in Wyerton and in Lions Head that have a sterling reputation. So let's watch that video, and then we'll be back with more with Alex. You're watching Rogers Television. This is Living Well, Giving Well.
Hi, I'm Brian Taylor. I'm a board director with the Bruce Peninsula Hospitals Foundation. The mission we have in our foundation is to provide exceptional rural care for the folks on the peninsula, and we do that by raising funds for our hospitals in Lions Head and Wyerton. So the foundation exists to bridge the gap in funding that is missing from the government. So the government provides funds for capital, for building a new building, putting new equipment in, and for the operating expenses of the hospitals, like paying the staff. But maintaining that equipment and adding new equipment and training staff is not covered by government funds, so we have to do that ourselves. So if we want to keep our hospitals current and keep the technology up to date and safe and efficient, then we have to raise the funds to do that. And along with that, if we don't have good equipment, we're not going to attract good staff. You need to look at it this way. If you or one of your loved ones, your friends, your family, have to come to emergency in Lions Head or in Wyerton, if we have state-of-the-art equipment and people who are skilled at using that equipment, you'll get really good care. So just look at it as if you're supporting yourself or somebody in your family or one of your friends. Would you want them to go to a place where things aren't up to date, up to speed, and the staff aren't energized and keen to look after you. By donating, you help support that cause.
Hi, everybody. Welcome back to Living Well, Giving Well on Rogers Television, Grey County. I'm Fred Wallace, and our guest today is Alex Wade. Our host sponsor today, or our host charity, is the YMCA of Owen Sound, Grey Bruce, and we'll be talking about them in our next episode, about the many features that they have at their facility that are very obvious and some that aren't so obvious, and we'll be talking about all of the various programs that they have. We want to thank the Bruce Peninsula Hospital Foundation. They're one of our many supporting and sponsoring charities of Living Well, Giving Well. Again, if you've received health care on the Bruce Peninsula, you know how valuable the hospital is, and while I've never been there, and I hope that I never do have to go there, what I understand from anybody that's been there is that the care is exceptional. They've got their Hooked on Health lottery coming up. That'll be at the end of the month, and somebody's going to win $5,000. But from the foundation standpoint, thank you very, very much to everybody that contributed and participated in that. We're talking wills with Alex Wade of Middlebro and Stevens today on Living Well, Giving Well. Want to go back to talking about the executor or the person that's most responsible. I chose the law firm to do it. Was that a good choice?
Yeah, in particular contexts, choosing a professional trustee is definitely a good choice. That's their business, right? So we're engaged in the administration of the estate. We look at it from a very objective view, just to get the job done. Like, this is, as we say, it's our profession. Estate trustees, yeah, they carry on a role of being the estate administrator. It's a role that carries a lot of responsibility. They need to be diligent in administering their estate. They need to also perform an accounting of the estate. Now, the accounting can be slightly an elevated duty if they do decide to take compensation in acting as your estate trustee, and all professional estate trustees are going to take compensation in acting in that role. They're also a great appointee if there's any sort of anticipated difficulties with any of the beneficiaries. If any of them are impecunious or should have substance abuse issues, or just to kind of devoid if you would habitually appoint a family member or trusted friend, it just removes them having to deal with that conflict that may arise. And the other thing too is that this individual is also going to be the one that may have to contend with any competing interests in the estate itself. So if anybody should challenge the will or challenge the estate plan, even charitable organizations, that sort of thing, this individual is going to be the one that's negotiating resolutions and being the first point of contact. So yeah, it needs to be a trustworthy individual. That's why we always recommend, in your particular circumstance, that was the correct choice. In other larger contexts, family contexts, you having a trusted family member, a friend, other professionals such as your accountant, your financial planner, and then you could also use a trust company if that would suit your purpose as well. And that's usually for very large, complex, high net worth individuals. They'll utilize a trust company because there's just so many interworkings that can go into an estate plan.
So assuming that I didn't use Middlebro and Stevens, which I was quite happy to do so, and thank you for your guidance and your help in that regard. Let's say that I chose a friend. How much do I have to tell that friend about what I have? Do I have to lay everything out for them, or should I just say, here's where you need to look?
It's probably best to keep that. People call it a death binder or some other. I just say keep it with kind of the personal effects, the important documents. It's always best to even annually sit down and review. What are my assets? What are my liabilities? Is there anything new in that respect? Do I see any issues in the future that I might want to try and head off now? So keeping that readily available and in a place where either you can direct them or it'll be easily found. Should you always advise your estate trustee that they've been appointed? That's not necessarily required at all.
Okay.
Things change over time. You may appoint somebody now, but maybe they go through a divorce or a bad business decision or something that changes, and you will need to revise your will and appoint somebody else into that position. So no, it's not necessary to tell them. The other thing too, and as I always tell all my clients, you can appoint them and never tell them about it. They would only find that out once you've passed and the will comes out. They don't necessarily have to take on the role. They can renounce from their position as your estate trustee. So again, it just depends. Like, that may be a reason why you want to have that conversation so that they're aware of it and
they're not
will
bombed,
accept.
but they're not perhaps grieving, and then also what?
Yeah, exactly. So again, that's why sitting down with one of us, being an estates lawyer, and having those conversations, we can discuss the appropriateness of the estate trustee you're intending to appoint and whether or not there are any issues with them going forward. Yeah.
You mentioned the death book, and I've hidden it away, and you know, the important people know where the file is in my place. In your experience, are you seeing lots of people doing that, or not enough people having the quote unquote death book or death binder?
I'm seeing it more, it's becoming more prevalent. Not that like I'm actually looking at a death book at all, but having that conversation with clients. It's not, truth be told, it's not something that's ever at the forefront of, like, say, and I don't mean to be rude or anything, but like my generation, being the 30 to 40-year-olds, it's not at the forefront of our minds at all. And so generating that sort of a document probably should be something that we're considering, but we're not at this point in time. But those that are nearing retirement and getting into their golden years, as we say, are definitely speaking about it a lot more. And that way they're also utilizing that for their planned retirement, making sure that they have adequate finances or any other issues that might arise. They're at least turning their minds to it with it.
So we're using the generation gap as a good example, one to the other, you being significantly younger than I am, Alex. You mentioned businesses. Let's say mom and dad own a very profitable business, be it a dry cleaning or a taxi operation, whatever it happens to be on a local level. Is it a different process? Is it a more complex process to make sure that everything is looked there in terms of succession, or if Junior doesn't want the business, which is also sometimes often the case?
Yeah. Businesses definitely add a layer of complexity to it. If you're doing your estate plan and you do own shares in a privately held corporation, not talking about the Tesla or Apple stock or anything else that you buy in
$9 Apple is up today as we do this interview. You may wonder how I know that, but I know that.
But yeah, so privately held shares in a privately held corporation are treated differently. You can actually avoid the application of probate tax, or what we call probate tax, the estate administration tax, by utilizing a secondary will. That allows your private shares to transfer outside of your primary estate, which is the one that goes up to the court, and you got to pay the probate tax, and where usually your real estate assets are held and that sort of thing. So yes, we want to make sure that you're putting into those instruments in place to assist you going forward. Secondary wills can actually be used in other contexts as well. If you've owned a home for a considerable amount of time, you can avoid probate tax on that home by way of a first dealings exemption. I won't get into the details of that, but again, this is why the conversations are important to have. With respect to sole proprietorships, you don't get the benefit of doing the same sort of thing with a secondary will. It would have to go into your primary will. That's why it might be a recommendation from a corporate solicitor that you do incorporate that business, and then it does fall into the privately held corporation, allowing you to access what's known as the lifetime capital gains exemption, which the government just put up to $1.25 million. So there's a lot of benefits there, because, and especially for succession planning going forward, if you need to divide up that business with multiple beneficiaries, it's a lot easier to do it with a corporate entity. There's other entities that assist too, and again, this is where an accountant would come in, perhaps a family trust or a holding company. I'm in the process of doing the same right now, setting up a holding company and a family trust going forward, just because that's going to benefit my family in the future.
All right, interesting time. I guess for every scenario, or there's no cookie cutter here, that there's all kinds of scenarios for all kinds of people, which means you've got to have the conversations both internally and with the experts.
Exactly. Yeah, there's so many moving parts in all of this. Yeah, there's no one size fits all at any point in time. So that's why it's always beneficial just to have that hour or two sit down with the lawyer and potentially the accountant. And at times we bring everybody in and do a roundtable discussion as well. We might as well keep everybody on the same page, and that way it's just a lot more expedited and economical as well.
You mentioned taxation, and what we're talking about on Living Well, Giving Well is leaving a charitable gift to an organization, whether it's a church, a school, maybe it's a group, maybe it's one of our sponsors, for example, Community Foundation Grey Bruce. Tell us about the ease and the benefits of doing that.
Yeah, leaving a legacy gift in your will is great. It really helps. On the largest tax bill you're ever going to pay in your life is on your death. There's a deemed disposition of everything you own. So that RRSP that's worth $300,000, it's as if your estate earned $300,000 in the year of your death. You can see that that's going to be a very sizable tax bill. If you left a $20,000 or $30,000 legacy gift to any of the charities, then that's automatically going to reduce that tax bill to the extent of that gift. So it really assists leaving more in the coffers at the end of the day, and it helps benefit your community at large. All of us get the benefit of utilizing the hospital or going to the YMCA. My whole family are members there, and my kids are on the swim club, so we're there more often than not.
Yeah, 6 in the morning.
Yeah. So we see the benefit in assisting that facility going forward, because I expect that my kids' will probably use the same thing at the end of the day. Yeah.
A sum of money left to a charity or a percentage left to a charity? Let's talk about those as we wrap things up, Alex.
Sure. So again, I come back down to the context. In particular instances, leaving a sum of money will be appropriate for certain testators to do. The thing is that denomination, whatever it is, comes off of the top. So if it's a $50,000 gift to the hospital foundation, and the totality of the estate is only $100,000 because you've lived a long and eventful life and it's been costly in your golden years, then that charity is going to get the first 50 grand. Your beneficiaries then split up the other 50 grand. That may not be the intended purpose of that gift. So you may want to shift and look at a percentage based in that respect, and then you could divide it up among many different charities if you decide.
This has been a great conversation. If people want to talk to you about their will, if they haven't started, or they want to review their will, how do they get in touch with you, Alex? Yeah,
they can contact us at the office. The number there is 519-376-8730. My direct extension's 232, or you can email us at my email is amw@mslaw.ca.
Well, thanks for being here today, and thanks for your guidance with my own will and my own legal activities. This is Living Well, Giving Well on Rogers Television. Our host charity today is the YMCA of Owen Sound Bruce Grey, and we'll be talking to them as the weeks unfold. And also we want to thank our friends at Bruce Peninsula Hospital Foundation. Again, if you have the means and the heart to do so, please leave a gift to them. We'll be back with more. We want to thank you again for watching Living Well, Giving Well on Rogers Television, Grey County.
Connect with us by visiting our website or email us at comments@rogerstv.com.
Hi, I'm Carol Merton, host of We All Belong, Our Neighbors, Our Community, a new Rogers TV series promoting the diversity of our community in Grey County. Please join me on Rogers TV.
It's closing time, and you stayed out longer than you planned. So now you can't drive, and the buses have stopped running. You could always call your girlfriend Or maybe your roommate? What about your best friend? You could just dial 1-888-TAXI-GUY or use the Taxi Guy app. The call and the app are free, and they both connect you to a local cab company to bring you home safely. Visit ArriveAlive.org to find out more. Arrive Alive, drive sober.